Hi, everyone. Thanks for tuning into our webinar. We're so glad that you're setting some time aside to learn more about civil rights in Oregon. My name is Sasha Grenier, and I'm the Sexuality Education and School Health Specialist at the Oregon Department of Education. I'm here with our ODE trainers for today, Karen Moskin, Civil Rights Specialist, Kate Hildebrandt, Title IX and Civil Rights Specialist, and Andrea Bybee, Program Analyst for the Sexuality Education Program. They all come with a wealth of expertise and knowledge and are happy to share this time and information with you. This webinar came out of a need articulated by many programs and trainers who work with teachers and school staff to better understand civil rights laws and issues. We've heard of many instances where trainers have had something come up in a training and have asked something like, is this discrimination? Is this bias? Is this just a value? Or is this protected by civil rights law? So we're here today to go through some of these basics of civil rights law that will hopefully help you feel a little more confident in addressing some of these issues that come up in your trainings and work with schools. So in that vein, our objectives for today are for you to better understand Oregon civil rights law and protections in the classroom and workplace. We hope that you'll be able to better identify the boundaries between personal opinions and laws. And we hope that you'll learn some helpful language to use to respond to comments and questions from trainees. And finally, we hope that you build confidence in your trainings, knowing that you are backed up by ODE and by the law. So we're going to go ahead and get started and delve into these issues, starting off with my colleague, Andrea.
Thank you, Sasha. My name is Andrea Bybee, as Sasha said, and I am a program analyst in the Sexuality Education Program at ODE. And I'm just going to do a brief overview of the federal civil rights laws that impact education. So starting out with the Civil Rights Act in 1964, Title VI protects us from discrimination based on race, color, and national origin and federally funded programs like public schools, which may have been visible through many changes like desegregation, for example. And then in 1972, protections on the basis of sex came in as part of Title IX of the Education Amendments Act, again in federally funded education programs, which may have started out looking like full-size basketball courts for women's basketball teams in high school and has evolved over time, mostly due to court cases, into including protections against sexual harassment and sexual assault in educational settings, programs, and activities. In 1973, Section 504 of the Rehabilitation Act prohibited discrimination based on disability in federally funded education programs, which evolved and grew in 1990 and beyond with the Americans with Disabilities Act, the ADA, into a more fleshed out accommodations analysis and process, as well as requiring accessibility in education programs. These are just a few of the major federal laws that support us all in accessing education and working in educational programs and activities with protections from discrimination and recourse for when it occurs. Federal guidance on these laws can change depending on the federal administration, as well as the many court cases that help clarify application of these laws. Keep in mind that federal law is the floor and not the ceiling, so each state is responsible to meet these requirements as a bare minimum. On the next slides, we'll look at some of Oregon's interpretations and expansions on these protections.
Thanks, Andrea. I'm Karen Moskin. I'm a Civil Rights Education Specialist and Methods of Administration Coordinator at the Oregon Department of Education. And we were hearing about the federal laws that prohibit discrimination. Oregon also has civil rights laws that provide many of those same types of protections. But I think that it is a good idea for us to be looking at what is it that we mean when we say it's prohibiting discrimination. What does discrimination mean? In Oregon, discrimination is defined as anything that unreasonably differentiates treatment, whether it's intended or unintended, whether it was on purpose or not, whether someone meant it or not. What we're going to look at is what was the impact on an individual or a population because of that act, or any act that might be fair in form, but discriminatory in operation. And what exactly would that mean? That means a lot of times there's something that at the time when it was put into place, maybe because those putting it into place came from a position of privilege, it seemed like a very good idea. But once it was put into place, the actual impact of it or the operation that took place was discriminatory. I think that more and more we're becoming more and more aware of systemic racism and systemic discrimination within systems that this would address and this would speak to. Another example would be something that could be even as simple as there was a school that I'm aware of that wanted to help our newcomer students to make sure that they had all of the help that they needed. And so in this elementary school, they thought that maybe a good idea would be for the students to have a little button that they wore so that the teachers would recognize them and know that these were students that would maybe need a little bit of extra language help. So it was fair and form because it was something that they thought would be helpful. But actually, when it was put into operation, then the students felt singled out and different and not as welcome as they might have been otherwise. So that's a really easy example of fair and form, but discriminatory in operation. And then the other very important piece of this definition is that it must be based on one of our 9 protected classes, which are age, disability, national origin, race, color, marital status, religion, sex, or sexual orientation, which Kate is now going to describe in more detail.
Hi, everyone. I'm Kate Hildebrandt. I'm Civil Rights and Title IX Specialist at the Oregon Department of Education. So as Karen just talked about, we have 9 protected classes listed out in Oregon law. You can see that these overlap with our federally protected classes, but Oregon's protected classes actually include a few additional ones. So anytime there is treatment that is based, as Karen talked about, on one of these protected classes, it could be discrimination. One thing that's really important for us to talk about here is we have these 9 classes enumerated, including sexual orientation, but our definition of sexual orientation in Oregon also includes gender identity and gender expression. As we're recording this in March 2021, there is currently a bill in the Oregon legislature that would separate out gender identity and create it as its own separate protected class. So as you're watching this, that bill may still be happening. It might not have passed, or it might be enacted. So we might have 10 protected classes in Oregon. Oregon has prohibited discrimination based on sexual orientation and gender identity for many years. And while that hasn't always been true at the federal level, this is also an exciting time because there has been some movement on this in the past couple of months. Specifically, earlier this month, there was a directive from the president to ask the U.S. Department of Education to review Title IX in light of how sex discrimination may impact discrimination based on sexual orientation and gender identity, since those can be discrimination based on sex as well. So a very exciting time for thinking about our protected classes, both federally and in Oregon. But what's really important for us to know is that if there is any kind of discrimination, different treatment, whether that's intentional or unintentional based on these classes, then that's something that we need to look at as potential discrimination. So on our next slide, Andrea is going to give us a couple of examples of how this might look and how this might impact in the classroom.
Thanks, Kate. Yeah, I just wanted to, like Kate was mentioning, those identities are protected because historically they may have been impacted by stereotyping, which has led to discrimination. We're going to talk through a cycle of bias that happens internally pretty naturally in all of us. We all categorize to make sense of the rooms we're in or the streets we're walking down, etc. And this categorizing happens so quickly and naturally that because your brain just really wants to help make sense of your surroundings. However, when our stereotypes, our thoughts, turn into unchallenged beliefs, they can become prejudices. The actions that we take based off of our beliefs can lead to discrimination. And the discrimination that we take can reinforce those stereotypes, reinforce our beliefs, our thoughts, because of just the natural impact these actions might have on a group or an individual. So we're gonna walk through an example on the next slide of just how this might show up in a school environment, and specifically coming from the sexuality education lens. So a stereotype that came up, we're just going to, oftentimes if we're presenting this live, we would do an activity where we ask people for examples. And one example that came up was on students with disabilities. And a stereotype might be students with disabilities aren't sexual. And if that thought is left to linger, then it might become a belief. Students with disabilities don't have sex, they don't have romantic relationships, etc. So maybe as a teacher or an administrator, and if you're holding this belief based on a thought you had, then you might take the action, which would be potentially discriminatory, by omitting students with disabilities from sexual education classes or programs or activities that are happening for everyone else in the school. This is just a pretty quick, it's not always a well thought out cycle, but once that action happens, it can often reinforce the stereotype and impact the community, the learning community significantly. It can hurt the students with disabilities aren't accessing the same education. The other students and the teachers involved are not seeing students with disabilities in the room, in the environment where sexuality education is being taught. So it reinforces the belief that perhaps they aren't sexual. Where are all the students with disabilities? Oh, maybe they don't need this learning because they aren't sexual, and it just keeps building on this stereotype. It leads to gaps in learning and about healthy relationships, sexuality, violence prevention, etc. So this is just a reminder about, depending on your role, but how your thoughts, they don't have to become beliefs. That when they do become beliefs, they can impact many people through your actions that you take. It's important to break these cycles wherever possible, internally, institutionally, and beyond. So in the next slide, we're going to learn more about how some of the actions that are taken based off beliefs can lead to harassment.
Okay. In Oregon and in other places as well, bias often and those stereotypical norms can lead to harassment. Harassment doesn't have to include an intent to harm. It doesn't even need to be directed at a specific target or even involve repeated instances. Sometimes just one would be enough. Under Oregon law, harassment is conduct that creates harm, fear of harm, or a hostile environment, and interferes with the student's access to educational opportunities. If the harassment is based on race, color, national origin, sex, sexual orientation, gender identity, religion, age, marital status, or disability, then it also violates civil rights laws that Oregon enforces. Some examples of where it might be discrimination versus harassment would be, let's say that students might be teasing other students because the clothing that they're wearing isn't maybe the trend at the time or something that the popular students are wearing. And so they could be teasing them about clothing that they're wearing. That would be considered harassment, and the school would still have the obligation to make sure that that student's access to educational opportunities or benefits is not being impacted and to stop that harassment. However, it would be different if the students were instead teasing and harassing a student because they were wearing clothing that wasn't stereotypical of a particular sex or gender stereotype. And in that case, say, for example, if they were teasing or making fun of someone who was biologically male wearing a dress, then that would be considered discrimination because it's based on a protected class. Kate's going to go into some more detail in breaking apart this definition of harassment in Oregon.
Because our definitions of harassment contain some specific language, we wanted to take a little bit more time to break these down. So one of the things you'll see in our Oregon definitions of hostile environment as well, or of sexual harassment as well as general harassment, is the term hostile environment. So a hostile environment is an environment that is intimidating, offensive, or unwelcoming. So something that potentially makes a student feel unwelcome or unsafe, like they can't fully be a part of that environment. It also can interfere with the psychological well-being of the person. However, as a person who's hearing about something, it's not necessarily to prove that there was a psychological impact. It's enough to know that a student is saying, I feel uncomfortable, I don't feel safe here, that can key in your mind that maybe there's a potential hostile environment going on. The second term is unwelcome conduct. So we hear this a lot in definitions of sexual harassment, specifically unwelcome conduct of a sexual nature. So I wanted to just take a second and talk about how we know something is unwelcome. The standard is not that a student has to actively resist. Sometimes people might hear unwelcome conduct and think that the person needs to have resisted or fought back, but that's not necessary. Not participating or not wanting it is simply enough. We also know that there's a lot of reasons why somebody might participate in something and still have not welcomed it. There can be a power differential, there can be fear of threats or coercion that's going on. So it's really important to examine that further. And that's something that should be looked into during an investigation of potential harassment or discrimination. The third thing we wanted to look at was limiting the access or ability to participate in an educational program or activity. This is a standard in a lot of definitions that the behavior needs to have limited somebody's ability to participate in or access something. So first off, I wanted to talk about what is an educational program or activity, because of course that's going to include the classroom and things that are happening on the school grounds, but it also includes other things. So extracurricular activities could be part of an educational program or activity. Same with athletics. Also things that happen off campus. So field trips, away games, a student waiting at a bus stop, even a fundraiser that's sponsored by the school at a local restaurant. Those could all be part of the educational program or activity. So it's not simply the location, it has to do with what is the school sponsoring, what is the school publicizing. If it has a nexus to the school, then it could be part of that. Now, limiting ability to participate in doesn't mean that the student needs to have quit the athletic team or stopped coming to school altogether for it to limit their ability to participate. Not fully participating is enough. So that could include that a student tells you that they no longer feel comfortable raising their hand in class and asking questions of their teacher because of some sort of harassment or hostile environment that's going on. Now, as trainers, of course, it's not your obligation to fully understand and analyze all of these things, but what we do want you to be able to do is understand that when you're hearing certain things, these might be considered harassment. So if a student's telling you, I don't feel comfortable doing this. I don't feel safe going to X club anymore. I don't want to go to this athletics team because of XYZ. That could potentially be harassment or even discrimination. So on the next slide, we wanted to look at the difference between these two terms. We've talked today about both harassment and discrimination, and sometimes people use these words interchangeably. And of course, they can overlap. Discrimination could come in the form of harassment. Discrimination is always going to be based on a protected class identity. Harassment could be based on a protected class or on something else, but discrimination will always be based on that protected class. When harassment happens that's based on a protected class identity, it needs to be treated as discrimination because there are specific rights and protections that are given to students who experience discrimination. It's the obligation of the school to recognize when something could be discrimination, regardless of the word the student uses. So if they say, I'm being harassed, I'm being bullied, but it's based on a protected class, the school needs to recognize it and treat it as such. So an example could be if you have a Muslim student who wears hijab and tells you that they're being bullied based on what they're wearing, that could potentially be religious discrimination or potentially even racial discrimination. And it's the school's obligation to recognize that and treat it as such, regardless of the words that student uses when they're reporting it. So on the next slide, we are going to talk a little bit more about what are the rights when students experience discrimination or within school generally.
Yeah, so we tend to get a lot of questions about this from educators and school staff. Such questions include what rights do students have related to free speech? What rights and regulations exist to prevent harm that may be caused? How do we create safe environments balancing and maintaining these rights while also preventing harm? What rights do parents have? What are students' rights to privacy? These are some of the questions that Kate, Andrea, and Karen will now walk us through.
Yeah, so just like federal and state laws often overlap, and intersect with one another. Quite often constitutional laws and protections also overlap and intersect with civil rights. The First Amendment of the US Constitution protects freedom of speech, religion, and the press. It also protects the right to peaceful protest and to petition the government. And in this definition of government, public schools are included. The meaning of the First Amendment has over time been the subject of multiple court cases and constant continuation of various interpretations and disputes over the years. And so it's something that's a living law that continues to be looked at and reviewed, and we continue to get more and more guidance about what it means. So the next slide, we're going to talk about free speech. So public school students have the right to speak out, to hand out flyers. So for example, if students are allowed to hand out flyers in schools, then they would be allowed to hand out flyers about GSA activities, as an example, and also petitions, and wear some types of expressive clothing in schools. For example, with that, there was a court case where students were allowed to wear black armbands because they wanted to express their grief and sadness over the Vietnam War. So that was an example of expressive clothing that the court said they were allowed to wear. However, schools can regulate student speech that substantially disrupts the functioning of the school or that invades the rights of others. So more and more courts are holding that schools can restrict lewd speech as well. Some examples could be that schools can ban wearing hats in general to school. That's okay for them to ban that, but they cannot say that the only hats that are banned are pink pussycat hats. Or schools can ban clothing or posts that have lewd pictures or lewd swear words or other types of language that would be considered lewd on those pieces of clothing. Next, let's look at how free speech can be impacted with a hostile environment. Public schools, as Kate talked about, have the responsibility to create that safe learning environment. And so the schools cannot ignore when harassment or discrimination is taking place. And this also includes anything that students, staff, or even third parties within the school community and within the school activities say, post, or wear. If any of those activities or whatever it is that they say, post, or wear creates a hostile environment at the school, then the school must respond, investigate, eliminate, and remedy that hostile environment. Some examples that we often hear about this are students or staff making anti-gay comments in class or in the hallways, or perhaps telling inappropriate jokes or racist jokes or other types of things where people would say, oh, it's all right, I didn't mean it that way, when indeed those would still create a hostile environment. Next slide is we're going to talk a little bit more about the dress codes. We've referred a few times about how there are various ways that student clothing can be considered discrimination. It is okay for public schools to have dress codes, but under both state and federal laws, these dress codes cannot force students to conform to stereotypes, and they cannot treat any students differently based on gender or any of the other protected classes. Some of the examples of situations that we've seen in Oregon are when dresses and slacks are required, dresses for the female identifying students and slacks for the male identifying students in band or choir. Instead, it should just perhaps be that students should just be dressed in black. Also, hairstyles or lengths we see is something that often school dress codes may conflict with what would be required or what would be allowed for students. So if hairstyles or lengths are looked at or treated differently based on a student's race or based on sex or gender, then again, those are protected classes and could not be different treatment. Another place where we've seen that is tuxedos being required at proms or prom dresses being required at proms based on gender or sex, and instead maybe the school should just say formal attire would be required. Also, we have found that often schools have had a history or a tradition over the years of males identifying students wear one color and female identifying students wearing another color based on the school colors. Again, should not be based on, should not be requiring, should not have different treatment because of someone's specific sex or gender, when it could be just as easily taken care of that students could select the color that they wish to wear during graduation from the school colors. Next slide, please. We often get questions about freedom of religion. The First Amendment, as we're talking about, also protects a student's right to freedom of religion. Students are under this allowed to express beliefs at school in their homework and in assignments. They're able to pray or study religious materials during their breaks or recess or lunch times, any non-instructional times before or after school. Or they can pray or discuss religion with other students during the day in the same way that they would engage in any other conversations. And as the next slide is going to tell us, when they're engaging in these conversations, then the same rules and policies apply about what those conversations are. Those conversations or that speech cannot create a hostile environment that's discriminatory. And what that also means is that they cannot dictate what others do based on their own beliefs or value systems. So an example of this would be that if a person believes that some gender identity, and so if a trans student identifies as female and using the female restroom, another student cannot dictate where that student would use a restroom based on their level of comfort. But if a student feels that they themselves are uncomfortable, then they can ask for alternative accommodations. Next slide. Kate's going to talk to us now about the rights for students to report when they feel like they've been discriminated against.
Thanks, Karen. So we've talked a lot about what students' rights are, what they can do, but also that schools have an obligation to protect students, to keep the environment safe, and that students can't interfere on another student's safe environment. So what happens if a student's rights are violated or they do feel like they're experiencing harassment or discrimination? Students have the right to report discrimination. Their parents can also report discrimination. Once a student has reported, schools are obligated to recognize the reports of discrimination and respond to them appropriately, regardless of the words or the complaint methods that a person uses. So we see sometimes an example where a student might not know that what they've experienced is discrimination, and they might instead say bullying or harassment or bothering me. Just because a student didn't use the word discrimination doesn't absolve the school of their obligation. If they're hearing in that report of bullying or of harassment that it might be discrimination, the school is required to respond. Likewise, some schools have reporting forms that they ask students to use, but whether or not a student or their parent uses that required reporting form, the school still has to recognize it. So there are many ways that a person could report it, and the school needs to respond. On the next slide, we'll look a little bit more at what some of that looks like. One of the obligations is that schools have to respond when they know or reasonably should have known about discrimination or sexual harassment. And that know or reasonably should have known standard is pretty broad. So again, with known, that could be that a student or their parent submitted a form. They also could have told a teacher, or a parent sends an email to a teacher, or staff witnesses the act. In all of those cases, that would be something where the school was clearly made aware of harassment. They can also be made aware of harassment through this reasonably should have known standard. In this standard, maybe a student didn't directly report it to someone, but the school should have been aware of it in other ways. So some examples of what that could look like are if a student writes about discrimination or harassment in an assignment that they turn in. Another example could be if detention is being given out for harassing or discriminatory behavior. If detention is being given out, that tells us that the school probably knew that the behavior was going on because students are experiencing discipline for that. Another example that we've seen in court cases and nationally is this graffiti idea, that if there's graffiti going on about discrimination, maybe there's lists of people going around and the school is requiring someone to go and paint over it. Well, that could fit in that reasonably should have known standard because the school is asking someone to go paint over it. They're probably being made aware of it. So on the next slide, we're going to talk a little bit about what happens once a school knows. When a school knows, they're obligated to respond and often investigate. But within that investigation of discrimination or harassment, all of the students involved are entitled to a fair process. So the school is obligated to respond, and then the reporting party and the responding party, so the person who experienced the discrimination and any parties who are reported to engaged in discrimination, have a right that the school does a fair investigation and reaches a fair decision. In most cases, schools use a standard of more likely than not for this. This is a pretty common disciplinary standard, and this is a pretty common federal law for federal civil rights standard as well. And so they're going to look at it and through that fair investigatory lens, make a decision of what has happened. They're also going to document this, and then it becomes a part of a student record. So on the next slide, we're going to talk a little bit about parents and how they intersect with this. Because often I find that students are really concerned about parents being notified in both directions. Some students are really scared of the investigation process or of being interviewed by an administrator, and they really want to have a parent with them and have someone there to advocate for them. For other students, they might be scared in the other direction. They don't want their parents to know about something that's going on. So we need to talk a little bit about what are parents' rights, given that most of the students that we're working with are under 18. So in Oregon, generally, someone is considered a minor until they turn 18 or become emancipated, and that gives parents or guardians right over that student. In terms of education, we look at the Family Educational Rights and Privacy Act, or FERPA, which tells us a lot about the rights of both parents to access their students' records and to make decisions for their students, as well as protects students and parents from those records being released. So it's a pretty complex law, but one of the things that it does is it gives parents or guardians the right to view student records until the student turns 18, becomes emancipated, or graduates high school. Of course, as with all laws, there's some nuances there. So we've included a link where you can look at that for more information. But a right to view a record is different than a right to do direct or an entitlement to direct notification. So what does that mean if a student is saying, I experienced discrimination? Is the school required to immediately call their parent? So FERPA doesn't require this active direct notification. A parent is always going to have a right to view that record. And so if a discrimination report or investigation becomes a part of that record, then of course the parent is always going to have this option to find out about it. But it's not an explicit notification requirement. So there's no requirement in FERPA that says you have to directly call parents when this happens. However, in general, I would say that notification is probably going to be a best practice in most cases, and many schools consider it to be their ethical or legal responsibility to immediately notify parents, especially for younger students. However, then we get into the case where sometimes notification might cause or exacerbate potential harm. We see this in a lot of students we talk to who might be experiencing harassment or discrimination or dating violence or sexual violence. And they might be gay or trans, and they might not be out to their parents and don't want their parents to know yet. And so they might want to tell the school and receive some of those protections that they're entitled to because they're experiencing discrimination or harassment, but they might not want their parents to know. And so what do we do in those cases? Because direct out of active notification is not that explicit requirement. What we encourage schools to do is to, one, of course, always talk with your legal counsel around this, but to make sure that we're screening students for the safety of parental notification when students are telling us, I don't want you to notify my parents. So make sure that, one, of course, you're adhering to any laws, any rules. Things can change all the time. I know, for example, right now, there is a bill that's in the legislature that could make some types of parental notification more required. So definitely check into any updates that occur, but we want to also make sure that we're supporting students and their right to privacy, and that they are being supported, that we're not putting them in additional harm by notifying their parents. So a bit of a nuance there, and the reality is that parents can always view that student records, but we also want to make sure that we're supporting them. So screen for safety and support accordingly. On the next slide, I wanted to address a very specific issue around parental notification, which is, can a school notify parents about a student's sexual orientation or gender identity? This is unfortunately a question that we've come up against, and that we've heard that may have happened for some students, or some schools have asked, can I tell the student's parents that they are using a different name and pronouns now? Or that I know that that student is LGBT, for example. This has come up so much nationally that the ACLU submitted an open letter to schools last August, um, telling schools that they should respect students' right to privacy when it comes to their personal information of their sexual orientation and gender identity. Schools should not directly notify parents just because a student has told the school that they are trans or that they identify a certain way. That student has that right to privacy, as the ACLU letter says. And so we really should respect that and shouldn't be doing that direct notification just because we want to, or we feel that the parent should know about that. I really encourage you to look at that letter and read the whole thing, because I think it's a really important piece for making sure that our students have their right to privacy and autonomy respected. So now that we've talked a lot about different rights, what is harassment, what is discrimination, let's look at a scenario of how this might actually play out in a situation that you might encounter. So I'll hand it over to Andrea to talk about this.
Thanks, Kate. Okay, so this scenario, an ESD employee at a training states that their district has chosen to have trans students use the bathroom that aligns with their gender identity, but only if the bathroom is cleared of other students beforehand. They share that this is based on values held within the district. Many other trainees are nodding their head in agreement. So we want you to think through, would this be discrimination or harassment? Why or why not? Which laws support your response? And how could you respond, or should you respond? So what we've learned so far is that when a protected class is involved, then it could be discrimination, regardless of the intent of the behavior, regardless if it's based on values. If the behavior led to the creation of a hostile environment, limiting access to educational services, et cetera, like access to a bathroom in a school, then it could become harassment. And we now know it could be both discrimination, harassment, or discriminatory harassment. The laws that support your response. We are going to talk a bit about some Oregon laws below that would impact the assessment of this scenario. But again, based on what we've already learned, sexual orientation, which includes gender identity and expression, are protected classes in Oregon. Like Kate was saying earlier, there is a pending bill right now that would parse these identities out into separate classes, which would likely lead to even clearer and stronger guidance and protections of the rights of students to be free from discrimination in education based on gender identity or expression. But for now, they are still included and protected through sexual orientation class. So some laws that might support it, like I said, we'll go into more detail, but we already know about these protected classes. And then in terms of how you would respond, well, it might depend on the role you are in. If you're the trainer, if you're a participant or a member of the ESD who's concerned by the practice that is being implemented in the community, just always knowing you have your Title IX coordinators in your district. ODE is here. we can be a great resource for responding, for offering guidance on how to respond, for working with your Title IX coordinator on responses as well, if helpful. And we'll be discussing other responses in the moment on a slide down below as well. But for now, Kate's going to go through some relevant case law for this scenario here in Oregon.
I think Karen's actually going to go through this slide. So Karen, I'll hand it over to you, but let me know if there's anything you want me to talk about.
No, thank you.
Thank you.
Thank you. And I was trying to unmute myself. So as Andrea just did a great job of explaining, gender identity is a protected class in Oregon. And also, as we've talked about already, discrimination within it talks about treating someone differently based on their protected class. And so in this case scenario that we just heard about, we're hearing that there's some different treatment of students based on their gender identity by requiring that the bathroom is cleared of other students beforehand. And so it's really important to say the school might say, well, we allowed them to use the restroom, but it's not just that, it's the environment that's created and the manner in which it happens. Oregon has some guidelines that were put out to give guidance to schools in creating a safe environment for transgender students. And within that guidance document, there are some great examples, as well as some guidance around pronouns, names, name changes, ways to deal with students' records, transcripts, or diplomas. So for example, we do have laws in Oregon that require that transcripts and diplomas are in a student's legal name. And so we also recommend that transcripts and diplomas, you would have two sets, one set in a student's name that they now are using, their current name, versus the legal name that they would have had before. So those are some examples of some of the things that you would find within the student guidance, which also includes the usage of restrooms and locker rooms based on their identity. We have a case in Oregon that received quite a bit of attention nationally, where a group of parents sued our Dallas School District regarding the use of restroom facilities that aligned with a student's gender identity. The district court dismissed the case and said that the school did not violate the rights of cisgender students. Quite often, as was said in this scenario, we would hear that, what about the values of the community? Or even if we think back to when we were saying somebody's religious freedoms, don't give them the right to dictate what someone else does. The same goes for the values within a community. The values within a community do not change what are the rights of that individual student who has the right to use the restroom for their own gender identity. And if there are other students who are uncomfortable, then they also would have the right to then ask for alternative restroom facilities for themselves, but not for someone else. Now, Andrea is going to talk to us a little bit about how do you interrupt when you hear comments like we just heard in this scenario? What are some of the ways that you can respond during a training?
Thanks, Karen. Yeah, so this the responding in the moment can be really tricky and challenging. And again, definitely often depends on your role and what feels authentic for you. But we're just going to go through two options, calling out versus calling in. Obviously, this is a spectrum, so depending on the situation, but just some points to keep in mind. Calling out is kind of more reserved for when you need to stop the behavior in the moment, because it's either causing harm, or if it's not addressed, it might continue and progress to cause more harm. So this doesn't mean, calling out doesn't mean you're necessarily seeking resolution and agreement with the other person in the moment. You're needing to just stop the behavior so it to minimize the amount of harm it's doing. So the act of stopping the behavior can be powerful in and of itself, especially for people who may be in the room and are the target of oppression or hold identities that are being targeted by the comments or behaviors. And hearing an ally call out behavior can work to build trust, creates a more welcoming learning environment for everyone. So some examples that are listed here that, these are just some samples, and we do provide later like a resource sheet that includes more thorough examples. But here are some in terms of the scenario we just went through. I'm not sure if calling out, if we had risen to the level of needing to call out, but the next example of calling in might be really helpful. So as facilitators, as trainers, as teachers, calling in is when, if the group, there's some group think happening, the comments are raising red flags, you're concerned of where the conversation might be going, or noticing that maybe a thought hasn't been followed through to its end point yet, and you can provide some learning and understanding and reflection. So going back to the scenario, for example, like walking the participants through their thinking, noticing the nodding of heads, the seeming agreement of some people in the room, perhaps using one of these questions, asking something like, what's making you most fearful or uncomfortable about the bathroom use? What is the connection between gender identity and bathroom use for you in the school environment? Just kind of trying to lead the conversation to a place of understanding, of maybe some paradigm shifting, and hearing people talk through what has gotten them to this belief that they're holding, this potential prejudice, right? That's now become an action in this policy that they've created, and a potentially discriminatory action. So calling in this scenario example would hopefully lead to more conversation and reflection. Again, your responsibility is in the moment to stop the behavior if it's causing harm, and to seek understanding when it's kind of just thoughts that can still be addressed. But please contact us at ODE to help with further responses if you have any questions. Finding your authentic voice and comfort level will also always help you more effectively facilitate and guide a conversation toward a path of learning and expansion rather than silencing or exclusion. Yeah, just remember civil rights protections benefit all of us, and we can show that through our responses and how we address the room. So that actually concludes our webinar for today. We hope it helps provide some clarity and new ideas for you around civil rights in education in Oregon and all of our responsibilities and protections that are included. ODE is here to answer your questions and provide guidance. Feel free to contact the Civil Rights Office anytime, or any of the trainers who are listed here. We've also provided a resource sheet to accompany this webinar to hopefully provide some more in-depth learning and answers to some common questions. We are hoping to offer additional webinars and trainings in these topics in the future, so keep an eye out for those opportunities. And again, just reach out to us with any questions. Take care.